Call now Miami-Dade County against William A. Davis.
Good morning. May it please the court, my name is Douglas Rice. I am here with Monica Rizzo. We're assistant county attorneys and we represent the county, where the employer self-insured in this case, and the appellate Miami-Dade County. I would like to take 15 minutes, if I may, with the court's permission to reserve 5 minutes for Ms. Rizzo to respond to the appellant's argument. In this case, we're called to...
We have this on the docket as 15 minutes per side.
Yes, sir.
So how much time do you want to take?
10 and 5 for my partner to respond.
Very good.
Of course, I think the issue today is pretty clear, spelled out. It's fairly clearly spelled out in the brief. We're here to decide how do we construct Section 112.18.1 in terms of its application to a firefighter who passes or fails to pass a pre-employment physical without evidence of heart disease. This case below, the court held that it is not the pre-employment physical that counts for invoking the presumption under 112, but the physical that's taken under 633.35 of the Florida statutes when the firefighter becomes certified. The problem with that holding is that the only requirement to become certified in the state of Florida under 633 is that you be in good physical condition. There's no requirement under that statute that you be examined for any disease that's covered in 112.18.1, hypertension, tuberculosis, or heart disease. There is absolutely no dispute in this particular case that the claimant had heart disease when he was hired by Dade County. He was hired by the city of Gainesville in '72. He had a certificate, a single-page form filled out by a government employee mailed to the fire marshal's office. That is the only evidence we have of whether or not he even went through an employment physical of any nature whatsoever. That form is not signed by a doctor. It's not evidence of a medical examination, and it does not determine what he was even examined for when he took the physical. Moreover, if you apply that standard, meaning that it's only the pre-employment physical that is taken at the time of certification, then the only possible way an employer will ever be able to defend a claim of a heart disease is whether or not we can show that there is some overwhelming medical evidence that that heart disease evolved for some other reason than the employment as a firefighter, because 112.18.1 clearly presumes that it's an occupational disease, and we're responsible for that except under very limited circumstances.
It might be helpful just to outline for us the sequence of events here. He first worked for the city of Gainesville.
He came to work for Gainesville in '72. He had a heart attack in 1992. He underwent double bypass surgery in 1992.
But he had a physical before he started with Gainesville, right?
We only know that he had a physical according to what piece of paper says he had a physical that meets the requirements of 633.35, which is that he's in physical condition, he's physically fit enough to be a firefighter. Not that he doesn't have a disease or what he was even examined for. And then after he goes to work for the city of Gainesville, there's a heart attack in 1992. He retires in '93 under regular retirement, goes to work for the city of DeQuesta, does not take a physical, applies to Dade County in 1995, takes the physical, which is admittedly clearly shows that he has heart disease in 1995. Our contention is very clear. It's the physical you take when you go to work for the employer. The quid pro quo spelled out in Cumbie is the exchange of coverage for you coming to work for me in good health. That's why we have the quid pro quo, and that's what the Cumbie court and this court said when they referenced the quid pro quo for that coverage. You know, quid pro quo is something for something. Doesn't make any difference if you pass the state physical. The state doesn't care.
All right, so then he had subsequent heart problems while surfing, while he was working for the city for Miami-Dade.
Yes, sir. In 2002, he was off duty surfing.
And he wants to invoke the presumption that that was job-related.
Correct.
And that requires looking at 112.18.
Yes, sir. He wants to invoke the presumption under 112.18.
Is that statute where we need to look to see that we're talking about the pre-employment physical.
That's the only place you need to look. This court has repeatedly held that the statute is clear and unambiguous, and this court has interchangeably used the term pre-employment physical.
So if we look at the statute, will we see the words pre-employment physical?
No, sir, you will not.
So what language in the statute are you relying on?
It says any such physical that says must pass a physical upon entering to any such employment, and it enumerates particular employment categories at the beginning or in the first sentence of the statute. State of Florida, county, municipality, fire control district. And it goes on to qualify that by saying must pass a physical without any evidence of heart disease, tuberculosis, or hypertension. And that's what you have to look to, and that's what this court has repeatedly held in almost 30 or 24 cases it has decided since Caldwell when it refers to 112.18. Nowhere in the annals of decisions involving the construction of 112.18 do we find any reference to 633, 34, 35, or any other statute. The only other statute that may be referenced is the 440-151 where we're dealing with occupational disease, but that is not an issue today. The only issue is which pre-employment physical counts.
All right, so under their view, your service as a firefighter should be looked at as a whole over the succession of employers.
Actually, under their view, you can come to work for the city of any city at one point in time. You can work for 4 years. You can leave for 10 years. You can come back, take the practical exam under 633-35, get recertified as a firefighter 15 years later and decide you want to go to work for another employer. Now that pre-employment physical, after you worked 4 years for Gainesville, had been out of work for 10 years, did something else, God knows what else, then you come to work for the second employer. That second employer gives you a physical or performs a physical. It says you have heart disease.
Well, if you let your certification lapse, do you have to get another physical?
No, sir.
Or if you have one when you're 18, you let your certification lapse for 10, 20 years, and you go back and start all over, you don't have to get a new physical?
No, sir. The only thing you're required to take is the certification, which is the certification practical exam, which is basically a knowledge-based exam. The Chief Casey, in this case, who is the fire marshal for the state of Florida, said there is only one physical required by law for certification purposes, and that's the one when you're initially employed by a firefighter. To be certified, you have to be employed. You can't be a firefighter in the state of Florida unless you're employed. One goes with the other. But going back to my original point, if you follow the holding in the court below or you allow it to stand, what happens is that once you've gone to work for an employer at any point in time, let's say you're 18 years old, and 20 years from now you've had 2 or 3 employers or you've even had a lengthy sabbatical, you want to come back and be a firefighter under 633, you take a written test, they give you back your certification, there's no more physical. But if your employer...
Well, counsel, if you take your position, though, let's assume the claimant only worked for the city of Gainesville a couple of months and found another job with you thereafter within 3 months. Would the claimant, under using your position, lose the presumption under 112? Since there was wasn't a substantial break in employment, you only worked for the city for a couple of months, and then you immediately found a job with you paying a higher rate of pay, and take that job. Would he lose the presumption under 112 under that scenario?
Well, in a recent case decided by this court, I think it was Paris, where there was a graduate from a fire academy, and he took his pre-employment, or he took the certification physical at that time, and immediately upon graduating the academy, actually it's not decided on this case, at this level, at a trial court level, immediately upon graduating from the academy, he went to work for a fire department. The judge of compensation claims found that temporally, in terms of the limited amount of time, and that obviously the physical taken at the time he went to the academy and the time he was employed were so closely related that you could almost count that as his pre-employment physical because the hiring city performed no physical. But I'd say under the usual set of circumstances, if you come to work for an employer and you don't pass their pre-employment physical, without evidence of any of the enumerated diseases, then there's no presumption that that's an occupational disease under the statute. That's the quid pro quo. It's our physical
You're down to 5 minutes.
Okay. And one other point I would like to make is that even if you find that the order below is affirmed or is correct, you still have to reverse and remand to the judge of compensation claims, because we do have a material issue, a genuine material issue in dispute. And that is whether or not there's any evidence that he in fact took a pre-employment physical when he was hired by the city of Gainesville. Gainesville admitted on the record they have no evidence of an actual physical, only a form that was completed by a bureaucrat and mailed to the fire marshal. The fire marshal has said that it was up to the city to fill out the form, and we accepted what they told us. We never required them, or at least we didn't require them at that point, to provide any supporting documentation. Holding that this order below stands from this point on severely changes the entire environment and how we handle these cases. Over the decades since Caldwell, the employers looked immediately to the pre-employment physical to determine if there is initial compensability, and then to other follow-up medical reports came from the treating doctors to determine if there is some other cause that went outside the bounds of 112.18.1. If you hold the order below stands, that's all over. We have no more defenses to 112.18, other than the fact that we may find in the very exceptional case that there's some genetic defect in the structure of the man's heart or the woman's heart. And sometimes you can't tell that until after they're dead. So you change the whole playing field in terms of the application of 112 and how employers and carriers are able to defend against those claims.
Would y'all have the same position if this firefighter, instead of having his heart trouble while he was surfing, he was in there fighting the fire, he was in the flames, had the heart attack, fell over dead, or was disabled from that point? Would you say you're not covered?
Not under 112.18. If he came to work with evidence of heart disease and 112.18 doesn't apply, then we're back to the Victor Wine standard. The Victor Wine standard, we know, is unusual stress or strain aggravating an underlying pre-existing internal failure or condition. Under those conditions, you may say fighting a fire, even though that's his job under a specific set of circumstances. You could consider that an unusual stress or strain and possibly compensable under Victor Wine standard, but not under 112.18.1 if he failed the pre-employment physical and he had the same disease.
But you say failed. There was evidence found of this heart problem, but you cleared him to work, or your doctor cleared him to work.
But it doesn't say, the statute doesn't say pass so you can either go to work or not go to work. The statute clearly says passes the pre-employment physical, which assumes that he passed and he's hired, without evidence of it.
You're below 2 minutes for co-counsel.
And with that, I thank you.
Your Honors, may it please the Court, I am Richard Sicking from Coral Gables for the appellee, William Davis. They pose two issues. One is legal, one is a competent substantial evidence question. The legal position that they take, the law is clearly against them and has been since 1978. The word in the statute is service, not employment, prior to entering into service. And in a case that was decided by this court last year, it's very recent, it's City of Tarpon Springs versus Michael Vaporis, it's case number 06-2995. This court pointed out that the use of the phrase pre-employment physical is inappropriate, and that the use of that term in the earlier cases was dicta, because the statute says prior to entering into service. It does not say prior to entering into employment or pre-employment. There is a difference. But it isn't new. The only case that's really just like this is the City of Melbourne case, which was decided by the Florida Industrial Commission in 1978, because it involved two employers, as this case does. In that case, the firefighter went to work for O'Galley, and O'Galley is one of those rare Florida cities that doesn't exist anymore. It was abolished and taken over by Melbourne. And when he went to work for O'Galley, there was no medical examination. But that's not surprising because it was in 1965, because the certification licensing statute with the medical exam to get the certificate wasn't passed until 1969, 4 years later. But eventually, Melbourne takes over O'Galley. He has medical exams then in Melbourne, which he passes. He has no evidence of heart disease, and then some years later, he's at his desk at the fire station, and he dies. And his widow makes a workers' compensation claim, and the judge of compensation claims found that, well, since he passed the exams in Melbourne without evidence of heart disease, he would have passed one in O'Galley had one been given, and so she should be entitled to collect the benefits. The commission reversed and said the statute reads the way it reads. He didn't have an exam in O'Galley, and that's the reason why Mrs. Anderson lost. And that case is exactly the same as this one, except it's the other side of the coin. The facts are rather simple. In 1972, he was hired by Gainesville. He had the certification exam because this was 3 years after the licensing statute was passed. Gainesville sent the exam form that the state had adopted to the state fire marshal, and the certificate was issued. He actually didn't have any evidence of anything regarding his heart with his annual physicals in Gainesville until 7 years later, when there was a mention of something about his heart, but it was said to be not significant, and there was no evidence in this record that that was heart disease. In the medical exams that were done thereafter, for several years, again, they were indicated to be perfectly normal. It was not until 20 years service in Gainesville that he had a heart attack. And he was treated for that, and the city of Gainesville accepted it as compensable, and they have made a claim over against Miami-Dade because they have provided the medical care for what happened to him in 2002. But they have not paid compensation, and so that is the claimant's claim against Miami-Dade for the compensation for the disability. Well, he went back to work in Gainesville, and then finished his term there, worked briefly in
So when he had the cardiac episode while in Gainesville's employ, the presumption was applied, and he did receive benefits.
Yes. In fact, if you look...
And then, in this case, although he was working for the city of Miami, the city of Gainesville picked up the medical.
Yes.
Isn't that the way it should work?
No.
And by the way, how does Gainesville parse it that finally, accepting responsibility for the medical benefits that were provided, but not for the compensation benefits?
I don't know. That's why they made a claim over. I guess they thought, if you look at 44039, where there's a dispute as to which employer should provide benefits, it encourages employers who could be responsible to pay the benefits and then make a claim over against the other employer rather than denying the claim and run the risk of doing something wrong. So that's the reason they did that. But when he goes to work for Dade County, not Miami City, Miami, he has the exam, and there's no question it shows evidence of heart disease, but they hire him. However, it is 7 years later before he has another heart disease episode.
Right,
but
so
what he's doing that has nothing to do with it.
If he had never been employed before as a fireman, the exam he took before he began with Miami-Dade, the results were such that he would not have enjoyed the presumption that you're urging.
That is correct, but of course it's not the facts of this case. Yeah. If that was his first job, if that was when he entered into service, that's what the statute says, then that's the way it would be. But because he changed jobs here, nothing changes, and that's the whole point of all of this. The purpose of the statute using the word prior to entering into service means when you enter into service. And now, under their theory, if it's an economic disincentive to change jobs, I mean, the legislature somehow meant, because the only exam that's required is the licensing exam, the one to get the certification. After that, there's none required by law. So all an employer subsequently requires to do is just not give the exam. And then
under your theory, a subsequent employer would conduct a physical and would never hire anybody that had any inkling of a heart problem, correct?
No. As a matter of fact, they did here. And in fact, the Mary Esther case certainly indicates that as well, that this is an occupational disease statute. In the Mary Esther case, the employer didn't change, but the carrier changed. And the question was, does carrier 1 pay or carrier 2 pay with the 2 different episodes? And this court held it's an occupational disease statute. We simply go on to the next one. The whole purposes of occupational diseases in this statute is simply that the person was, quote, clean when they began their career. Under their theory, all an employee would have to do is change his job. They don't have to give the exam, none is required, and then he's deprived of these benefits. The legislature would not have intended that. What he was doing in 2002 had nothing to do with anything, because their evidence, which is Dr. Pianto, said it was just, that's page 265 and 266, the normal progression of his disease. So the whole purpose.
You say that there is no statutory requirement for a medical examination before employment begins.
Only for the certification. That's why the trial judge...
Aren't you ignoring statutory changes, the one that excised the word initially?
No, because first of all, this man, when he was hired, the statute was actually in chapter 163. I'm sorry, 166. 163 is right, 470. So that when he was hired, it said simply that he had the medical examination. There's no evidence that he didn't pass the medical examination without evidence of heart disease. That's page 3738 of the record. The people from Gainesville were asked, the answer is that no, there was no evidence that he failed the physical, thank you, without evidence of heart disease. Answer correct. So he passed the physical examination. All the evidence is that he passed the physical examination in Gainesville. And that's all the statute requires. When Miami-Dade hired him, they knew he had heart disease, but they wanted to hire him anyway.
But is it 633, 35, maybe it's 34, that requires, it says that you can't hire a fireman as a fireman, somebody with a felony and so forth?
All sorts of things, yes.
And isn't there in that statute a requirement for a medical examination?
Yes, that's the whole point. That's the only one required by law. And that statute, although it originally appeared in 163.470, was passed in 1969, which means the legislature knew about it in 1973 when they enacted the presumption statute, making it applicable to workers' compensation.
All right, so if somebody gets the original certificate, is discharged from employment as a fireman because of various arson convictions, and then gets a job as a fireman in another municipality, you say the presumption, you say that statute doesn't apply. It only applies to the initial certification?
The only medical examination that's required by law of any kind, any law, by the legislature, is the one to get the license. Just like passing the bar one time is all you need to do to get your license as a lawyer. Now, there's certain things you have to do afterwards in terms of continuing education. There's certain things that firefighters have to do afterwards, too. But the only medical examination there is the one prior to service for certification. And that matches the statute for the presumption which says prior to entering into service, not pre-employment. The legislature certainly has enough ink to have written it the way they like, but they seem to have invented this new square wheel, which is contrary to everything that we've done. And by the way, their interpretation would not be applicable just to workers' comp, but also to the Florida retirement system and the pension plan of every city. It's a disincentive for firefighters to change employers, because if they do, then they would lose the benefit of this presumption. And there's no indication that the legislature ever intended anything as absurd as that. The question of competent substantial evidence to support the judge's finding that he did pass the physical without evidence of heart disease in Gainesville is overwhelming. Certainly he could take every inference that he could about that. We're talking of something that happened years ago. Gainesville, one of their arguments is, well, we shouldn't believe Gainesville. Well, because they're making a claim over. Well, the judge is the one who decides that, and he did believe Gainesville. The legal question, whether it's the exam when you begin your career, and then no matter how many times you change employers, should not in any way change the fact that you have complied with the statute, which is passed a medical examination prior to entering into service, which failed to reveal evidence of heart disease. That's all the legislature ever required. The judge was correct, and he should be affirmed. Thank you.
I'd like to start off by addressing two questions that I thought were very pertinent to this argument that were asked by Judge Roberts and Judge Benson. Number one is whether 633 requires a physical, whether that's the only physical exam that's required. 633 requires that the physical exam that's passed demonstrates good physical condition. That's it. Whereas 112.18 requires a more stringent requirement. It requires that physical exam should not have revealed any heart disease, tuberculosis, or hypertension. As evidenced by this specific claimant, somebody could have one of these diseases, heart disease, hypertension, or tuberculosis, and still be in good physical condition, which is why Miami-Dade County hired him. He was 47 years old. In the record, it's that he was a world-class athlete, a surfer. He may have had heart disease, but he was in good physical condition. They're two different standards. He may be able to work. It's just he will not be compensable for that pre-existing condition. Second.
Well, it's not even that he would not be able to get compensation. It is that he would not automatically get it under the presumption.
Correct. Not automatically. If he could establish it under 440 workers' compensation or the Victor Wine standard, he could then. It's just he would not get the presumption.
In the case law, there's no prior instance where Chapter 633 has been looked to in this connection.
No. And as a matter of fact, from a common sense, the logical conclusion would be exactly what Judge Roberts said, which is this man at 44 years old had his heart attack. From that point forward, no city, no municipality is going to touch him with a 10-foot pole if they have to pick up any kind of injury he has for that pre-existing condition. So he, despite the fact that he could very well work for another 20 years without any problems, the county would never have hired him, nor would any other city.
Well, Counsel, we accept your position. Anytime a claimant changes employment and he loses the benefit of the presumption under 112, wouldn't we be undermining the public policy considerations behind this act itself?
No, Your Honor, I don't believe that you would. Like my co-counsel stated, this quid pro quo was granted. This is the only time where they don't have to prove that the disease was caused by virtue of their employment. It's the presumption is given to them if they can demonstrate that they entered into working with that employer without evidence of hypertension, heart disease, or tuberculosis. If they've satisfactorily passed a physical exam without evidence of those diseases, then that's where the public policy is enacted. And the purpose behind the statute is from that point forward, you will presume that it developed because of their work for that particular employer. I'd also like to point out that the city of Gainesville actually said on the record, there's no evidence anywhere on the record that they picked up this claim as compensable under 112.18. They specifically say that they compensated him for it, but they don't know why. In addition, the city of Gainesville said, and this is from the record on 36, my co-counsel asked, my question to you is with reference to the city of Gainesville, whether it's your position or not, as far as the city of Gainesville is concerned, that Davis passed the pre-service medical examination without any evidence of heart disease. The response was, we don't have a document to that effect. There's no evidence, even aside from the Miami-Dade County physical, that he even successfully passed one in 1972 without evidence of one of these diseases. Moreover, in the city of Melbourne, in that case, the court doesn't say that the only exam that's required is the one before the first employer. As a matter of fact, the court specifically points out more than once in their opinion that he didn't have a physical upon entering employment with the city of O'Galley, and he didn't have a physical when he first began employment with the city of Melbourne. It was several years after he was employed at the city of Melbourne that he had his first physical.
All right, thank you. You're well over your time.
Oh, thank you. We simply ask that you reverse the summary final order, and rule for and with instructions to rule for Miami-Dade County in the alternative that you submitted to trial because there are factual issues in dispute. Thank you.
Thank you. We will be in recess for a few minutes, and we invite